of WBEV or Good Karma Brands. And joining us from the Daily Dodge TV studio is Wade Bates.
Thank you very much, Jeff Hall. Happy chilly Monday to you. And this is Taking Care of Business, the Melick Law Show on 95.3 WBEV and Daily Dodge TV. And that brings in can we say the star of the show, Rob Melick?
I don't know about the star, but I'm happy to be along for the ride. Good to see you again, Wade.
Good to see you too. So tell me, how many people do you think you've interacted with this morning so far?
This morning, well, I've had 3 appointments this morning. I can tell you that. But as far as other interactions, I've had obviously emails and all that other stuff, phone calls. Monday tends to be loaded with those. So
I was going to say, how many people started with, "Hey, cold enough for you out there today?"
Always, yeah. And I got gas at Fleet Farm on the way in, and that's all people could talk about. So I get it.
See, you're like me. I have my daughter's car. I was supposed to fill it up last night or yesterday, and then all of a sudden this morning she's got like a quarter tank or less in it, and it's like, okay, you got to fill it up because it's going to be cold the next, and it sits outside.
Right.
So I'm like, oh.
Yeah, that's what I did for my wife yesterday. I took her car out, filled it with gas, so that hopefully she doesn't have to do that.
Yeah, and then the other thing happened is on one of my kids' vehicles is the window thing broke, so window dropped in, so their window was wide open.
That's not good
for the weekend. We got a foot of snow inside the passenger side seat.
I say wrong time of year for that to happen, unfortunately. So.
No, but we have somebody taking care of that tomorrow, and you can take care of people in a lot of different ways, can't you?
Absolutely, yeah. When it comes to can't really help too much with car windows. No. I'm not a real handy guy, but I could definitely help with estate planning, and obviously that's the purpose of the show here, just to educate people on what the estate planning options are out there. It's one of those areas of law. It's interesting. Again, for those of you who don't know, unlike perhaps a lot of other professions like the medical field, for instance, you graduate from medical school, you do residency in the area that you're likely going to be practicing, and that's generally how it goes. With law school, it doesn't really work that way. You graduate with a general degree, general law degree, and then depending on the firm that hires you, that's what you focus on, and you either like the area, you don't, you can switch areas, things like that. So a lot of attorneys are generalists, especially in smaller towns. You go, let's say 100 and some odd, 50, 160 miles up north, most of those attorneys up there outside of your big cities like Wausau, Stevens Point, are typically being general practice attorneys. They do whatever comes in the door. They might be defending a criminal one day and doing a personal injury action the next. It's just whatever comes in. Whereas some attorneys like myself focus on one area, and that's what I do. I focus on estate planning. So that's been the bread and butter of my practice for 14 of the 18 years I've been practicing. Trusts, wills, powers of attorney, probate. Those are the kind of things that I do day in and day out, and just through shows like this, educating people as to what their options are, and letting them kind of sift through some of the hype from what's actually real. It's like anything else. For whatever reason, I don't know why this field, maybe I'm biased because I do what I do for a living, but it seems like there's a lot more what I call armchair attorneys out there in the estate planning field than in the criminal defense field. I don't think, and I do have buddies who do criminal defense work. I don't think many people come into their office saying, well, I heard about this, or I should do this, or should be the strategy. They defer to the lawyer in his or her experience. But with estate planning, there's just a lot of information out there, whether it's on the internet, whether it's through other people. And a lot of that information is either incorrect or more often incomplete. Yeah. I think incomplete is probably the better word for it. It's not that it's incorrect. It's just, yes, that might be the preliminary step, but there's other things we need to consider before we make fully informed decisions.
That's one of those things, too, where, I do some shows at hospitals and such, and they always talk about, doctors will go into medical school and they're not quite sure what route they're going to go to. When you started law school, do you think you're going to be like the next Perry Mason? Did you think you were going to be Law and Order? And how did you end up discovering this great field to be in?
Yeah, so kind of in between those two, what ended up happening was I'm the son of 2 police officers, right? So going into law school, I thought I was going to be a prosecutor. That's kind of what I thought. I wasn't too wed to it because, again, first generation lawyer, I'd heard that was the idea, right? Go into law school with an open mind, see what you want to do. I was an economics major in college, so when I first got into law school, I enjoyed a lot of the tax courses that I took, but then it ended up getting to a point where the rubber hit the road, and I had graduated and I needed a job. So I ended up working at what they call a commercial litigation firm. So it's not exactly Perry Mason, but it's in court.
Sure.
It's mostly defending corporations. The firm that I started out with did predominantly construction law. We represented a lot of general contractors, subcontractors, suppliers, architects, things like that. So that's where I started for the first couple of years of my practice and just decided it wasn't for me. Ended up working at a more general practice firm that had a bunch of attorneys who did a bunch of things. And one of the attorneys that I worked with was an estate planning attorney. And one of the things he said, and I'll never forget this, I was a young attorney, just 2-3 years out of law school. And he said, estate planning attorneys tend to have the highest job satisfaction among all types of branches of the law. And I said, well, why do you think that is? This guy was in his 60s, late 60s when I was practicing with him. He's in his 80s now. And he said, well, there's really two aspects of estate planning that are different than most other areas of the law. One, you don't have opposing counsel. Right? When you're in a case, Perry Mason's arguing and he's making his case, you have a prosecutor, you have a defense attorney, there's only going to be one winner, right? It's either the person's innocent or guilty, right? Or not guilty or guilty, right? And in a civil case, someone's going to win money, someone's not going to win money. In a divorce case, it's adversarial. But with estate planning, it's more collaborative. It's meeting with people, coming up with common goals, things like that. And opposing counsel exerts pressure, and that tends to be stressful. And then the other thing is you don't have court deadlines. A lot of times most attorneys are very deadline-driven practices. I have to submit these reports by this date. I have to conclude depositions by this date. Here, it's basically, in probate there'll be some deadlines, but even those are pretty flexible. But when it comes to meeting with clients, it's just that. It's sitting down, meeting with clients, coming up with a plan, and having a non-pressure-filled amount of time to do that. So, and the final thing he said is, dealing with people. It's what they call lawyers call it a client-facing area of practice. Things like estate planning. Even divorce is client-facing. You're dealing with clients all the time. Whereas, if you're doing corporate law or you're doing litigation, you're not dealing with clients every single day. You're prepping for trial. You're writing briefs. You're doing legal research. Things that I certainly can do, but one I don't enjoy. And two, with all humility, I think I'm better at having conversations with people than I am, doing those other tasks of the law. So, it's an area of the law that not many people are in. My law school graduating class at Penn State was about 250. To my knowledge, only 3 of us are estate planning attorneys. So it's an area that kind of surprises me because it's an area everybody needs. You know what I mean? Everyone's going to die. Not breaking news here, right? We're all going to pass away at some point. Whereas not everybody's going to go through a divorce. Not everybody's going to get accused of a crime. Not everyone's going to have a personal injury. Those are the other areas that most attorneys practice in. So I'm kind of surprised fewer attorneys don't get into estate planning.
So we're talking with Rob Melick from Melick Law. Again, if you have a question right now, you can give us a call at 885-4446, or I have the text line in front of me as well, 920-887-9595, and we can answer those because it's one of those things, and I've talked about it before, and I have no problem talking about my personal. I can talk about and bring up my personal questions to you and tell my story, but I was a person I didn't know much about it at all, just knew that I was kicking the can down the road, and I'll do it next week. I'll do it next year. I'll do it in a couple of years, when you have kids and you're trying to figure out what's going to happen. And even if you don't, what's going to happen when you die. And person like you, hearing you on this show, when I wasn't hosting, got to get this done. And finally, I maybe put it off like 3 or 4 times. And finally, I said, Rob, we got to hammer this out because there are probably a million people like me out there that, they know you have to do it. But because if you don't, there are consequences that could cause your family stress and just cause a lot of anguish in what would be a trying situation if something bad would happen.
Absolutely. You're in very good company. I hear that story hundreds of times a month, a year, of people who they know it should be done, right? I mean, if you polled 100 random people who don't have an estate plan, my guess is maybe 10, 15% would say, oh, I don't need an estate plan. The other 80, 85, 90% would be like, well, yeah, I need it. It's just time isn't right now. And you delay, you procrastinate because it's not a known event, and I'm sure we all have examples in our personal life. And the most common one, which is kind of around the corner, is tax season, right? People will delay on that, but you know what? You got to file by April 15th, or you need to get an extension, right? I mean, it's a call to action. The problem is this call of action, death. We know it's going to occur, but we don't know when. So, if everyone had a crystal ball and they knew they were going to pass away on X date, well, probably about 3 weeks before X date, people would get their estate plan done, right? But that's not reality. So, I encourage my clients to create the documents and have that peace of mind for as long as possible, because at the end of the day, that's what an estate plan does. It creates that peace of mind to avoid the anguish, the anxiety, the cost, the aggravation, the publicity, the delays of not having an estate plan in place.
That may be one of those things too, where I'm sure that you've seen it, where people don't think about it, and then maybe they go in for their annual physical and they get some bad news, and then it's like, oh, we have to, and obviously if you get some news, that you maybe have something, you don't want to be thinking about. You want to be able to think about fighting what you have in that, as opposed to saying, I don't have my estate plan done. What's going to happen if this battle goes the wrong way?
Absolutely, and that happens quite a bit. And hopefully, and I say this just purely from an estate planning standpoint, hopefully when you have that hypothetical thing that goes wrong or bad diagnosis, you still have capacity. Because that's the thing. If you're incapacitated, we can't do an estate plan for you. You have to be lucid. You have to be able to make those decisions to have that plan created. And absolutely, I mean, I understand estate planning is not the be all and end all of it. You want to enjoy the time you have with your family. You want to make sure that that you're enjoying as much life as you have if you have a really terminal diagnosis. But at the same time, this needs to get done. It needs to get completed. So, and I do help people at all stages of life. I mean, I have a signing tomorrow at a client's home. She's 95. She's bedridden at this point, but we go there. We have the documents notarized, all that good stuff, and it's enforceable because she's lucid. She has capacity. She's weak, but she has capacity. So again, I can help people pretty much in any situation so long as they have capacity. And we do rush things if we need to. The analogy I think of is, again, going back to the medical field, is the idea of triage, right? If I'm in the emergency room and I have a really, really bad headache and nothing works, and I'm the first in line and a guy comes in with a gunshot wound, they're going to see the gunshot wound guy ahead of me, right? And they should. It's kind of the same thing with estate planning. If I have clients who are terminal, clients who are in rough situations there, we can certainly expedite that. I can also expedite it for trips. I prefer not to do it for trips because that's a choice, not a situation. But, if time allows, we'll put them to the front of the line as well. But again, it all starts with a phone call. It all starts with a call to Melick Law. Again, for those of you in the listening and viewing audience, predominantly, the closest office location will be my Beaver Dam location. Sandy and Matt over at Hire Insurance generously allow me to use their office to meet with Beaver Dam area clients. So they're over in the old Heritage Hills Mall between what used to be Joann Fabrics and what used to be Sears. So that's the place in Beaver Dam. But I do also have offices in other places. My main office location is in Saukville, not Sauk City. I get that wrong. People get that wrong all the time.
They're the long drive.
Complete
go the wrong
opposite
way.
direction, yeah. Because I've had people say, "Oh, you had to go through." No, it's east. Saukville is basically on Lake Michigan. It's about 5 miles east of Lake Michigan. I'm sorry, west of Lake Michigan. Excuse me. Just on the other side of Port Washington, which of course is on the lake. So my main office is in Saukville. I also have office locations in West Bend and Germantown. Free initial consultation. I always offer free initial consultations. Again, I do not want people to have to pay money to get information, because the information in and of itself is great, but it doesn't move the ball. You can be as knowledgeable as you want on any topic of estate planning, but if you don't actually have the documents in place that effectuate that plan, it's kind of useless. So free initial consultations. And then I do also offer a 20% discount for WBEV listeners or dailydodge.com viewers. So if you do decide to give me a call as a result of seeing the show, mention you heard me here, 20% discount off of legal services. I do also offer in-home visits as well. I do have some clients, as I mentioned before, my client who is in bed. If my clients have mobility issues, if they would simply prefer to meet in their homes, maybe I have a lot of clients who don't like driving in this kind of weather. I'm happy to make that drive. Or I have some younger clients who don't want to get a babysitter. They'll just throw on a video for the kids to watch. And I think I dated myself when I just said video there. But
pop in the VHS.
Yeah, there you go. The old beta deck. No, they'll put something on the TV and the kids will watch it while we meet. Whatever works. Again, best way to get a hold of me, any of those office locations, is the same number, 262-347-3444. Again, 262-347-3444. My name is Rob Melick, M as in Mary, E-L-I-C-K.
How did your relationship begin with the Hires?
Yeah, good question. So, and a little bit of background, I guess, would be helpful for this question. I grew up in Washington County. That's where I grew up. But I did go to college and law school out in Pennsylvania. I played college football. I was getting recruited to play at a college out in Pennsylvania.
Penn State?
That's right, to law school. I wish I could say I played football at Penn State. I didn't. I played football at a Division III school, but I did go to law school at Penn State. So I was out there, and I ended up out there for the first 7 years of my legal practice. Ended up marrying an East Coast girl and finally convinced her to move back to Wisconsin. So I've been back in Wisconsin for 12 years now. But what ended up happening was when I first joined the firm here in Wisconsin as a young-ish estate planning attorney, 32 at that point, I just reached out to anybody and everyone I could find, any insurance agency, bank, financial advisor, and just sent out a cold letter saying, hey, I'm an estate planning attorney. I don't know if you have a relationship with anybody else, but I'd love to talk to you, get together for coffee, whatever you want to do if you want to learn more about our practice. And Sandy actually reached out. Sandy was one of the very few people who responded to that. And as it was turning out, the attorney she used to work with was retiring. So it was one of those things where, out with the old, in with the new, I guess, so to speak. And I've been working with the hires ever since for 12 years. It's been a wonderful relationship, and very grateful to have the opportunity to continue working with Matt here.
And those go hand in hand, don't they? The two businesses, which you both kind of go hand in hand when it comes to people trying to secure their future. Both, it's a marriage made in. I don't want to say in the courtroom, marriage made where, just a marriage made in financial planning and holding your future.
Exactly. And, the analogy I always use there is we're all on the same team,
yes.
Right? When we meet with clients, we are all on the same team of advancing the client's objectives, whether it's through financial estate planning, insurance, working with accountants if necessary, whatever the case is. We're all on the same team. We all bring different attributes to the team, with the common goal, of course, of making your lives easier, making your lives better, keeping more of your money, and making sure assets go where you want them to go with no governmental interference.
885-4446 if you have a question, or you can send a text, 920-887-9595. Rob Melick from Melick Law here on 95.3 WBEV and Daily Dodge TV. Now, Rob, one of those things, people always talk about, we mentioned kicking the can down the road. Some people think, I can just write on a cocktail napkin, I scratch it out. I leave everything to my wife, Crystal, that is in my name. Sign it, put it in somewhere, and just say, you can take it into a courtroom and say, look at this. I wrote this down. I signed it. Even if I got it notarized, probably isn't going to do the job for what you're looking for to secure what happens if you would pass.
Yeah, it's not enforceable that way. Again, to be clear, handwritten wills can be enforceable, but they have to meet a lot of stringent legal formalities that, again, most non-lawyers are not going to know about. And I'll tell a story. I think I've told this one on the radio before here. Obviously, when it comes to stories, I can't divulge client information, so I speak generally. This is one of the more sad stories I've had in my practice, and this was, oh goodness gracious, this was like probably 8-9 years ago. Right when I first opened my firm, I had a woman come into my office the Monday after Thanksgiving, and she was a wreck, absolute wreck. And I asked what happened, and she said that her father had committed suicide over the Thanksgiving weekend, and he had written a very thorough will. Okay, he'd written a very thorough will where certain assets were going. I mean, this thing was probably 14, 15 pages of loose leaf, just down and down. And it didn't have the formalities that a will needed to have to be enforceable. So I had to tell her that not only is this will not enforceable, we have to go through probate, and his wishes are not going to be honored unless the people who are receiving these under Wisconsin intestacy laws, which is just Latin for dying without a will, wanted to give these assets away. I mean, he had very specific instructions of things going to grandchildren, to great nieces and nephews, to the neighbor across the street. I mean, all these things. And again, the way it works under Wisconsin law is if you do not have a valid estate plan and valid enforceable estate plan at the time you pass away, state of Wisconsin creates one for you. In which case, he had no spouse, had 3 surviving children. It would just be divided a third, a third, a third. Well, that's not what he wanted. He wanted very specific items. And unfortunately, because it did not have the legal formalities that a will needs to have to be enforceable, because he didn't go through a lawyer, all of those intentions are going to go to the wayside here. So I had to explain that to her, and we had to go through probate. And it was one of those things where it's a tough lesson. I mean, obviously dealing with your parents' sudden passing obviously is hard enough, but then let alone the additional time and aggravation of not only having to go through that probate process, but knowing that even though Dad articulated his wishes very thoroughly, they're not going to be enforceable because the document's unenforceable.
So if it goes down to like a third, and if he wrote a will by hand that said, okay, I want the furniture in the house to go to child A, I want the vehicles to go to child B, I want the vacation home in Paducah, Kentucky to go to child C, if you don't have it correctly done, does it end up being, if everything's got to be a third, do you sell it all and split the money, or how does that work then?
Well, basically what happened is the court would get a personal representative or an executor assigned. So one of the children, in this case, the child who came to see me, she was appointed as the executor. Fortunately, the kids agreed, because if the kids didn't agree, then there would be a fight in court regarding who'd be the executor. Now, when it comes to distribution of assets, again, if everybody agrees to it, you can just do it that way. So, for example, that vacation home, I'm making up numbers, but let's say that vacation home is worth $400,000 and the total estate is worth $1.2 million. I'm cherry picking numbers here, right? If everyone agreed, then we could say, okay, child A gets the vacation home, and then everything else gets split between the other two, because that $400,000 home represents the 1/3 that they'd otherwise be entitled to. The problem is we can't put 10 pounds of sugar in a 5-pound sack, right? If that vacation home is worth $1 million and everything else is worth $200,000. I know that's an exaggerated example, but you get the point. They wouldn't be able to keep that and still maintain the 1/3 that the state would require through intestacy laws. So, again, it's one of those things where if siblings get along, it's not required to all be sold. And the other thing too is, there's what they call a de minimis exception, and there's nothing in Wisconsin statutes regarding what it is, but it's common sense. The example I try to give, and again, not related to any law, but I look at $100. If something is worth less than $100, don't even worry about it. If there's used clothing, if there's kitchen appliances, things like that, just have it go how you want it to go. If it's less than that, then it should either be allocated, or more than that, it should either be allocated to that particular child. In other words, you say, okay, the snow blower is worth $500. Okay, well, if you want the snow blower, that's $500 coming out of your thing, and either we find something worth $500 to the other kids to offset it, or you essentially buy it from the trust. Again, horse apiece in terms of how you want to do that, but that's generally what I see in my practice.
So Rob Melick from Melick Law here on 95.3 WBEV and Daily Dodge TV. Rob, again, if somebody's looking to make an appointment, how do they find you again and get that initial consultation?
Yeah, so best way to do it is by phone. I do have the 4 office locations, as I mentioned before: Beaver Dam, Saukville, West Bend, Germantown. The number is the same for all three: 262-347-3444. Again, 262-347-3444. I do have 3 outstanding paralegals who are ready, willing, and able to answer the phones. I typically have someone in the office between 8 and 4:30. It does vary. I have one of my paralegals on vacation today. Lucky one there. She's heading out to California, so she'll be on vacation. But the other 2 paralegals are in the office. And like I said, barring something catastrophic, somebody being sick, there'll be someone there to answer the call between 8 and 4:30. And if we're on the other line, we'll give you a call back right away.
And a lot of people just think that it's like, we talked about, you mentioned estate planning, you mentioned trusts, and somebody's like, oh, I need to have a will somewhere. Well, there are many different options. Wills are one option, but there are different benefits to having a will, having a trust. And if somebody was like me, wasn't quite sure what they needed, can you kind of just start out when somebody says I need a will? What does a will actually do?
Yeah, so that's the most common question I get in my practice, Wade, by far. What's the difference between a will and a trust? And again, it goes back to something I mentioned earlier in the show, this idea of, the internet can be a blessing and a curse, right? If we were having this conversation 40 years ago, before the proliferation of the internet, people would just rely on what the attorney said, or maybe talk to neighbors. But now everyone can go on the internet. It's like the WebMD thing, right? Just go on there, self-diagnose, and go from there. So obviously a lot of times the information on the internet is incomplete. Maybe it's not applicable to your situation. The other thing with that is, 50 different states, 50 different sets of laws. So if somebody's writing a random blog on estate planning and that person happens to be from New York, it could be completely different than how it works in Wisconsin. But the main question I get in my practice is the difference between wills and trusts. And the way that I explain it, and again, this is a conversation I've had thousands of times in my career, is I always start with what a will is, what it does, but then maybe more importantly, what a will does not do. So you're right. When most people think of or hear the phrase estate planning, the most common word by far is will. I need a will. I should have a will. Well, again, what does a will do? What does it not do? So a well-drafted will is always going to do 2 things. And when applicable, it's going to do a third. First thing the well-drafted will does is determine who are your beneficiaries. Who or what, in the case of charities, are going to receive the proceeds of your estate after you pass away. Second thing a well-drafted will does is determine is who's in charge. A person's called an executor, who is going to be in charge of your estate, paying out final expenses, making sure that your assets are distributed in accordance with your wishes. Third thing is interesting because it doesn't apply to everybody, but for those for whom it does apply, it might be the most important thing we talk about here, and that's guardianship of minor children. I know we both have children under the age of 18. I will tell you, parent to parent, the most important thing an estate plan can do is determine guardianship of minor children, because if you and your wife or me and my wife pass away while we have at least one child under 18, if we do not have that guardianship provision in either a will or a trust, courts will determine guardianship of the minor children. Literally nothing else works. You talked about that handwritten letter, completely unenforceable. I have clients who say, well, we made a videotaped statement saying we want our sister to be the guardian. Useless. It has to be in either a will or a trust. So again, to summarize, in broad terms, what does a will do? Who gets the money? Who's in charge of the money? Who gets the kids? Okay. The problem or the limitation with will-based planning is that wills are not guaranteed to avoid probate. Okay, and that surprises a lot of people. A lot of people, when they initially meet with me, well, what do you mean? Well, because a lot of people have heard the term probate before, but they incorrectly believe that if they have a will, the estate will avoid probate. To be clear, wills can avoid probate, but they're not guaranteed to avoid probate. But we're getting a little ahead of ourselves.
Sure.
What is probate? Okay,
That's a big question people ask.
Absolutely.
They're like, well, what do you mean, Rob?
right. And what they'll say, and again, they have a general idea,
Yeah.
but I like boiling it down to one sentence. Probate is the process where a court oversees the administration of an estate. When a case goes to probate, there's a series of hearings, a series of filings, a series of deadlines, series of events that occur before assets go from the name of the deceased to the names of the intended beneficiaries. Okay. Three main reasons we want to avoid probate. First is cost. Average cost of probate in a state right now in the state of Wisconsin is between $8,000 to $12,000. Second is timing. Average length of probate in the state of Wisconsin is 12 to 18 months. Third issue is publicity. Wills become public record when they go through probate. Not only does the will become public record, but the amount and the character of the assets also become public record. How do we avoid probate? Well, under Wisconsin law, there's only two ways to avoid probate. First way is this, and I'm talking about either a single, non-married individual or the second of a married couple to pass away. Because generally speaking, for a married couple, when spouse one passes away, probate is not implicated. That's not always the case, but it's usually the case. So we fast forward to that moment in time when that person has passed away. If the value of the probate assets is less than 50 for those viewing, $50,000, that is considered a small estate. And under Wisconsin law, small estates avoid probate no matter what. Now, of course, the opposite of that statement is also true. If we fast forward to that date of death and the probate assets are greater than $50,000 and you only have a will, the estate goes to probate. Now, we have to be clear as to how we define what a probate asset is, because not all assets are probate assets. Let me define it. A probate asset is any asset that does not that does not have a live named contractual beneficiary. Okay, and all of those terms are important. A live named contractual beneficiary. Okay. Going back to the example you said before, I hereby leave everything to my spouse. Is that a beneficiary? Sure it is. Is that a contractual beneficiary? No, it's not. A will's not a contract. Contractual beneficiary would be, I have a life insurance policy. That comes as part of a contract. I sign the life insurance policy. I pay my premium in exchange for the company giving me the promise that if I am up to date in my payments, and I happen to pass away within the terms of the policy, the insurance company agrees to pay that money to my beneficiaries. That's a contract, okay? So if I have beneficiaries on that account, it will avoid probate. Maybe. Okay. And see, that's what I've learned here, Wade. 18 years of practice, I have learned that clients hate when the attorney uses the word maybe. But maybe is 100% the correct example, and I'm going to explain why. If I didn't have a trust, okay? If I didn't have a trust, how would I list beneficiaries on my account? Well, my wife for life insurance, because life insurance can't be jointly owned. Okay, bank accounts are different. We'll get to those in a second. But like for life insurance, I would list my wife as a primary beneficiary, and I'd list my two sons, Grady and Hudson, as contingent beneficiaries. Those are named contractual beneficiaries. Will that avoid probate? Again, the answer is maybe. Why? Because of the very first word I said, alive. I have no idea whether either or both my sons are going to survive me. I hope they do. Statistically speaking, they're likely to, but it's not a guarantee. I have no idea whether either or both my sons are going to survive me. And in fact, I will not know the answer to that question until the day I die. Up until the day I die, that is an open question. That applies to every single person in the listening audience, right? The difference is the trust creates the guarantee, because there is not a human being on this planet that has a 100% chance of surviving any other human being on this planet. The trust, however, has a 100% chance of surviving you, because the trust can't die.
Sure.
And that's the only guaranteed way to avoid probate, is to create a trust. We can get to highly likely, perhaps, when it comes to listing beneficiaries, but the only way to get that guarantee is to create a trust. That's why I'm a fan of trust-based planning, because it creates the guarantee. 100% chance the trust will survive you. Not the case with any human beneficiary, even one that's one, let alone maybe even 2 years, 2 generations younger. We don't know. And we're not going to know up until that day. So creating the guarantee through the trust is what I recommend that my clients consider there.
Talking with Rob Melick from Melick Law here on 95.3 WBEV and Daily Dodge TV, and you talk about that. What percentage of people come in thinking they just need a will, and then after kind of looking at the facts and talking with you, end up going, I think, you know what, Rob, you're right, we need to do the trust.
Yeah, here's what I would say. I would say among the class of clients who need a trust, okay? Because not all clients need a trust. Some clients don't have $50,000 worth of probate assets, or maybe they're planning to give it all to charities, and the charities we know will survive them too. So that's maybe 5 to 10% of my clients. The other 90%, I'd say 2/3 of them come in thinking they want a will, and 90% of that group ends up creating a trust. Because again, my job is, and a lot of people don't understand this, so I have to explain this very carefully. A lot of people think that I, as the lawyer, tell people what to do. I don't. My clients are my bosses, okay? My job as the lawyer is to educate clients on what the pros and cons are of either action or inaction. It is the client's decision. They're my boss. So if I have explained the shortfalls of simply creating a will, and for whatever reason they decide to create a will, guess what? I create a will for them. So that does happen occasionally, because will-based planning is less expensive than trust-based planning. Some people take the position of, you know what? I want to spend less of my money now. I don't care if my kids have to spend 4 times that amount of money after the fact. They're getting all this money when I die. I want to keep as much money for me. That is a perfectly valid way of looking at it. That's not how most of my clients look at it. Most of my clients look at it and they say, gee, if I can save my children significant sums of money by paying this now, I want to do it. I want to create the trust to put it on a silver platter for them, so they don't have any administrative costs, and they certainly don't have the cost of going through probate. Again, different strokes for different folks. Again, I educate. I let people know what the pros and cons are, answer their questions, give them the opportunity to make a fully informed decision.
And that's one of the big reasons why, when people are to the point where they figure they're ready to do it, to come talk to you in your office, because you said like with WebMD, you can search stuff on the intraweb, you can find stuff that you can fill out, but the odds of you without any experience actually getting 100% of the stuff on there correct and could cause problems in the future, where your staff and we went through the thing with you, you know, was painless to go through, and all the T's are crossed and the I's are dotted.
Right, you bet. Here's an analogy I draw, and we were talking about this off air earlier today. I'm not a very handy person. I might be the least handy person you ever want to meet, but here would be my analogy, okay? If we picked 100 random people in this audience who don't have an estate plan, okay, and I asked them this, let's say the transmission in your car failed, okay, just failed one day. Would you repair it yourself? Probably not. I don't, if we picked 100 random people, I don't know how many of those people would have the physical ability to do it, right? I mean, you got to get down underneath the car. You got to be able to lift heavy things, let alone the technical expertise to be able to do it. And if you screw it up, the consequences are significant, right? You pay a mechanic to do it, right? There's differences. Even though I'm not a handy guy, I mean, I always call it the continuum of car care, right? To very basic stuff, right? Pumping my own gasoline. I'm sure you can pump your own. We were actually talking about that too. Pumping your own gas, right? We talked about that, right? You talked about how you filled your daughter's car up, right? Same kind of thing, okay? Changing a flat tire. There are fewer people who know how to change a flat tire than know how to pump their own gas. But there are more people who could change a flat tire than can replace a transmission. So it goes up in difficulty, right? I think it's a fair analogy for estate planning. There are very few people who are going to be able to play, town square lawyer to be able to draft the trust appropriately. And if you don't get it right, it goes to probate. Dire consequences there. So that's why people hire attorneys to do that kind of work, just like that's why they hire mechanics to replace transmissions.
I tried to fix a stove on YouTube, and then when the I failed, when the people went to deliver the new stove, they took the old stove and they opened up the thing and they were like, why are all these parts inside the stove? I'm like, I tried to do it myself.
Exactly. And it happens. And I get it. I understand the idea of wanting to do self-help because even as unhandy as I am, you try to do that, right? I mean, I have very few successes when it comes to handy stuff, believe me. But one success that I did have is we had a clogged toilet. Okay. I looked at it. I diagnosed it. I'm a pretty smart guy, not handy, but I figured out what the problem was and I fixed it on my own. Now, save myself, a couple $100 from having the plumber come out, right? But for every one success that I have, I probably have 10 failures when it comes to, or 10 of, nope, I'm not even doing it. I mean, as a matter of fact, today, we have a couple issues in our house. I have a client who's a handyman. I called him up and say, hey, come on over, give me an estimate to fix these things because I don't even want to deal with it. I'm going to have a professional do it. I'm going to make sure it's done right. Someone who knows what they're doing. So I don't even attempt those.
No. And Robin, if somebody's kicking the can down the road like I did as well, and it's not a long process. See, sometimes you think you put it off because you're like, oh, I don't have hours and hours to get all this information together, and I need to, I'm going to have to find this and this and this and this. It was a pretty quick. We had our initial meeting with you. We decided we're going to go this route, and the process was relatively quick. And the information that there's some basic information you need, and then your people put it all together, and then you maybe come back and do a signing later on.
That's right. And again, different attorneys do it in different ways. I've heard from many existing clients who said they saw another attorney and the paperwork process was just so voluminous, and it doesn't have to be. Again, with all humility, I've streamlined the process. I mean, it's just as enforceable, just as valid, but perhaps I don't need the same thing. I can elicit the same information from a conversation that I can from compiling documents. I can instruct my clients on how to do things without having statements from a bank. A lot of times they'll say, okay, give me your most recent statements from every single account you have. I don't need that. I can educate my clients on what to do with various types of accounts without needing the statements, because the statements are just that. They're a snapshot. When we met, however many months ago it was, you could have changed your whole entire financial portfolio in the time, right? So the advice I would have given you at the meeting would be obsolete now. Instead, what I do for you and for every single one of my clients is I say, okay, assets fall into these groups. I don't care whether you have one checking account or 10 checking accounts. I don't care if you have $1 in checking account or $1 million in your checking account. My advice is still the same, because it is going to change. People had accounts now that they never had before. The example I give is this. It's tailed off a little bit, but about a year and a half, 2 years ago, CDs were at like 5.5%. Well, during COVID, they were at like 0.2%. Nobody had CDs in 2020 because it wasn't profitable. Now people have CDs. So if I met with someone in 2020, they wouldn't have gotten the information about CDs because they didn't have any. Well, now they do. What would they do? They'd call my office, and again, happy to talk to them. But the way I do it is I just give very broad information regarding classes of assets as opposed to individual specific assets. That way it's generally applicable and doesn't matter whether or how you change your portfolio.
If you're a married person, you do a trust and such, is it one of those things where you and your spouse have to be in it jointly together, or do you do them separate? Can you do them separate, or what do you need to do?
You can, but it's very rare. Very, very rare. Given Wisconsin marital property laws, most people do them jointly. Again, and when it comes to the information, when I have initial consultations, I don't need to meet with both spouses. I can meet with just one. But then before we sign, the signing has to be both. And then if that's the case, I have to make sure that the spouse is thoroughly on board with everything before we actually sign any documents. So I do have to go through that process, but it's not a very difficult process to go through there. They just make sure that we're on the same page. Because a lot of times, especially if I have, people who both work, maybe it's just easier for one to get there as opposed to the other one. Or, I have a lot of clients where spouse A is retired, spouse B still has a couple more years on the job. Well, it's easier for spouse A to get there for the initial consult, and then for the signing, of course, we need both.
Now, what are some of the things, and people are thinking about this, and then when I'm stopping, kicking the can down the road, and kick it right into Rob's office, so in your locations. What are some of the things they have to have in the back of their head that they need to have and have together before they have that initial meeting with you?
Yeah, so what I always recommend people do is, and again, different people keep it differently, but I would need the names, addresses, and phone numbers of anyone who's going to have a role under the plan. So agents under powers of attorney, things like that, having their information handy at that first meeting is pretty helpful because, again, I don't keep stats in my office, but if I had to guess, I'd say 4 out of 5 people who meet with me decide to go forward at that meeting, okay? And the 1 out of 5 sometimes need more time or sometimes they decide to go in a different direction. That's fine. But if we're going to kill 2 birds with 1 stone, we might as well have all that information we need in the event that we do end up you guys do end up deciding going forward. So having that information, then also having an idea, and it's something I can talk through with clients and will talk through with clients, but having some sort of idea as far as order. You have 3 children. Well, among those children, whom do you want as a primary backup under healthcare power of attorney? Couple factors to consider, one being geography. Geography matters for healthcare power of attorney because many times with medical decisions, time is of the essence, right? We need to make sure that we're on board with getting someone there who's going to be able to make decisions quickly. So geography's thing. Another issue would be what the person does for a living. I mean, these are factors. One is not dispositive, but they're things to consider. All things being equal, someone who is in the medical field is probably a better option than someone who's not in the medical field. If you have a child who's a nurse or a doctor in California, they're probably a better option than someone who's not in the medical field in Wisconsin. Those are things to think about. The amount of time that a person has, right? I mean, when you're talking healthcare decisions, that person's going to be making a lot of decisions, taking a lot of time. So maybe the spouse that has the ability to dedicate more time to that decision is a good option. So these are all factors to consider. And I walk my clients through that at the meetings because a lot of the times my clients will come to the meeting, they'll decide to go forward. I'll ask those kind of questions and say, well, I want both my kids on there. I'll say, okay, you can do that, but then it requires both. They have to agree. If they don't agree, then we have problems. If child A says, pull the plug, child B says, use that experimental treatment to keep them alive no matter what, how do you resolve that deadlock, right? So these are all factors to consider. But again, same thing as I mentioned before. If my clients are insistent on having joint agents, that's their choice. It's their documents. They can have them however they want. I have done my job as the lawyer once I've explained the pros and the cons of doing it. It's their documents. They can have them however they want.
Again, it's an important thing to get done and make sure because you never know. You never know when it's going to be needed, right? It could be me walking out the door today. You never know. Maybe a piece of icicle could drop off. So take care of it, and then you have peace of mind for everybody. And one of the big things I always talk about is making sure people know where your documents are located as well, right?
You bet. And what I always encourage my clients to do there is when it comes to their children, most commonly children, of course not everybody has children, but whomever your agents are going to be, whomever your trustees are going to be, do one of 2 things. Option 1 would be, and the more common option I think is let them know where the documents are and make sure they have access. Now, one thing I will tell my clients is about 2 to 3 times a year I'll get a call from a child. I did the parents' estate plan. They'll be like, well, how do I get into the safe? I don't know. I have never in my 18 years of practice taken a key from a client. I've never once taken a combination to a safe from a client. I have no idea. So make sure your kids know how to get into the safe if you keep them in a safe. Or if you're going to put them in a non-locked place, make sure they know where they are. Or the other alternative is to simply give them a copy of the documents. People will do that. Again, it's personal preference. Some of my clients want to keep that very private and only on a when needed basis. Other clients are like, I just want them to have immediate access. Again, client preference in that regard. But it is important to communicate where they are.
Rob, how do people get in contact with you if they want to make that initial appointment or call or just to find more information?
You bet. And I'm happy to do that as well. And if there's just information, there's questions you have, just give me a call. One other thing I will mention too is I also will review existing documents on a complimentary basis. People come to me, I had these documents drafted a while ago. I just want a second set of eyes. What do you think? And I'll walk them through it, give them my professional opinion on them as well. That's done on a complimentary basis, as is the initial consultation. Best way to get a hold of me is by phone. 262-347-3444. Again, 262-347-3444. Offices in Beaver Dam, Saukville, West Bend, Germantown. 20%. I make house calls as well, virtual calls, FaceTime, Zoom, and 20% discount for WBEV listeners and DailyDodge.com viewers.
And you do keep copies of everything on the cloud, right? So you do have, for some reason, if you'd have something where you would have a fire or something or a flood and it got taken away, you do have copies of everybody's information on the cloud within your office.
You bet. And to be clear, attorneys are not required to keep client documents. But again, because we have the cloud-based system at our office, we do retain an electronic copy of all of our clients' documents. It's the most secured cloud system we can find. Our IT guy put us on the best plan possible because it's very important that not get compromised.
Rob, it's January 19th. Just so you know, 1 month and 2 days is our first Brewer broadcast here on 95.3 WBEV.
Can't wait. Spring training. Pitchers and catchers are reporting about 2.5 weeks. I'm looking forward to it.
Excited for the Brewers this year?
I am. I had low expectations last year, and they obviously moonshot those expectations. It'll be interesting. I don't see Freddie Peralta remaining as a Brewer. I think they're going to trade him, but they've made out on the past couple trades. Corbin Burns trade, they definitely did well on. The Devin Williams trade, they definitely did well on. So I think they move Peralta, and I think they get a good return for him.
Well, always high expectations with Melick Law, and you always live up to those expectations. You did that with us. You finished in first place with our trust that we did.
I sure appreciate that.
All right, Rob Melick from Melick Law here on 95.3 WBEV. We appreciate Jeff Hall for spinning the dials and pushing the buttons back up at the Global Media Center. And again, you have been listening to the Melick Law Show on 95.3 WBEV and Daily Dodge TV.
All right, thank you.